When deputies are called to a construction site for a suspicious person, they find a shocking scene. A high school art teacher allegedly caught having sexual contact with a student. Now she's on administrative leave and faces some major jail time if convicted. We're taking a closer look at the case of Jennifer Massey. I'm Gillespie, and this is Law&Crime News. This is 51-year-old Jennifer Massey of Selma, Texas. She's an art teacher at Davenport High School in San Antonio. But this alleged incident happened just north of this city in Comal County. On October 3rd, deputies there got a call for a suspicious person at a construction site where a home was being built. When officials arrived on the scene, they found Massey, who was apparently engaged in sexual contact with a male student. She was arrested and charged with improper relationship between educator and student, which is a second-degree felony. So far, it's unclear what exactly this sexual contact was or even how old the boy is. But even so, Massey was placed on administrative leave from her school. On October 4th, the Davenport High School principal released a statement. It reads in part, quote, "The district learned that last night, Mrs. Massey was charged with having an improper relationship with a student. Mrs. Massey was placed on administrative leave this morning and she will not be returning to Davenport High School. I know it can be quite disturbing to learn that one of our teachers was charged with a crime such as this. Please know that I and members of my administrative staff are available to address any concerns you may have regarding this situation. Also, if your child has any concerns or questions, our counselors are available to meet with them as needed." The statement added that the district's Human Resource Department conducts background checks on all applicants during the hiring process. So that means Massey was vetted before she was hired on. Okay, I know you're multitasking when you're watching our videos, and if you're out and about running errands, listen up. I have to tell you about the free app Upside that gets you cash back on daily essentials. I use it now every time I pump gas because it's so easy to use and free. Here's what you do. Get the Upside app and claim an offer for whatever you're buying. So you pay as usual and then just follow the steps on the app to get paid. To find out how much you could earn, click the link in the description to download Upside or scan the QR code on the screen and use our promo code LCNews to get an extra 25 cents back on every gallon on your first tank of gas. Right now, the incident is still under investigation, and Massey is being held at the Comal County Jail on $50,000 bond. If convicted, she could face up to 20 years in prison and a $10,000 fine. To make sense of the case as we know it right now, we're turning to criminal defense attorney and former sex crimes prosecutor, Serena Townsend. Okay, so for this story, I just wanted to start with the very basics. The fact that we have a teacher here engaging in sexual contact with an underage student, obviously a minor. To start, isn't that just a huge violation and betrayal of trust?
Absolutely. When a person decides to become a teacher or some sort of caretaker for a child, certainly we expect them to have high morals, high ethics, and to care for them, not to violate that code, not to do bad things to them, certainly not criminal acts, certainly not sexual acts. So yeah, just in and of itself, a teacher who is tasked with those extra special access to our children, we expect them to act appropriately.
Right now, we don't know that much about the case, but what we do know is that they apparently engaged in sexual contact. That's what police are saying. But what does that really mean? Does that mean that they for sure had intercourse, or are there different levels? What could it all mean?
Right. There could be different types of sexual contact. So obviously the most extreme sexual contact would be intercourse. But there's other types. There's touching, there's grabbing, there's groping. There could be a mouth to another body part. There's a lot of different ways that sexual acts can be broken down. And in fact, we look at them in the law at different levels. I mean, if there was sexual intercourse, she could be facing a higher degree felony than if there wasn't.
And maybe that'll give us a clue as to what actually happened, because she is facing a second-degree felony. The charge is improper relationship between an educator and student. So could we kind of infer what happened?
It's interesting with that charge. If that's the top count and it doesn't speak to the age of the person, I do wonder if this student was an older student, maybe 17 or 18 years old, because I would have expected there to be a charge having to do with, either rape or sexual assault of a minor. And if the person was of age, then it's possible that the only felony that she could be facing has to do with the actual relationship of her being that person's teacher. There are extra charges that we have in the penal law when somebody takes advantage of their position like that and a teacher has sexual contact with a student, whether or not that student was quote unquote a child.
That's interesting. I want to dig into that part a little bit more because 18, we hear that number. Okay, you're an adult now. You can obviously give consent. So technically there could be some consent there, but it's still illegal, you're saying, because she was a teacher and this is a student?
Exactly. And the idea of somebody being an adult, it's interesting. We do see people as adults under the penal law, under our criminal, practice. But are they really adults? I mean, there's so many studies out there that have been shown over and over again that people's brains don't even fully mature until they're at least 24 years old. And so it is interesting. But yes, technically, if this student was 18, it's quite possible that there are a limited amount of charges that she could be facing. But yes, one of them has to do with the fact that she was his teacher.
I'm wondering if it's important for investigators to go back into their relationship, whether this was a one-time thing they just got together or if they were having an ongoing relationship for some time.
That's an excellent point because, yes, apparently they found them engaging in sexual contact on this day in particular in 2024. But you're right. A lot of times, especially when it comes to teachers and students, there is grooming that happens. There could be years worth of grooming that occurs. And yes, I think absolutely investigators need to look into this relationship. When and how did it start? Whether there was sexual contact before, because if there's under the law something called coercive sexual conduct, that is in and of itself oftentimes a different felony, where if this teacher had been engaging in sexual contact with this student who might have been a minor at the time of the initial encounter and then engaged in what's called a coercive conduct, they had several interactions that were inappropriate, there could be additional charges, yes.
And how important is social media or cell phone data in a case like this? Obviously, most of us keep our phones with us. I mean, I have mine right here. It's with us all the time, so it can track our location. Then we have our texts, our call logs, social media like Snapchat or Instagram. How important is all that for the investigation?
So important. And we see it again all the time, especially when you're dealing with children or young people. I mean, you and I might be using our phones all the time, but imagine children. I mean, they grew up with cell phones, basically grew up with the internet. And so they're very reliant on it. And a lot of times, again, because of a lack of maybe maturity or understanding, there are things that are written down on text, in Snapchat, pictures, other forms of evidence that is exchanged via, your cell phone that could absolutely support an investigation and further charges here. I mean, even if the teacher asked for images or a video or something of that nature, and then ended up publishing it somewhere, that could be another felony charge on, that she could be facing. So absolutely, there needs to be a robust examination of all of the evidence here. I would have, yes, asked a judge to subpoena her internet use and her phone to see whether there were those exchanges, and of course her social media too.
We've covered many, many stories, dozens, I want to say, that are similar to this. And you pointed out an important thing, the photos or the images, the videos. And this is something we've seen kind of as a pattern, that a lot of these teachers who are committing these acts are recording it or taking photos, videos, all of that, which just shows that they were participating in this illegal activity. Why is it that they do that? It's something that we see quite often, but obviously is very incriminating.
Yeah, we see it a lot. It's kind of a compulsion, and it's probably the same compulsion that drove them to commit the crime to begin with. You have this memory, this wonderful in their mind and horrible in everyone else's minds memory of this event that you had been chasing. And it's kind of like a trophy. You hear of other types of criminals committing other types of crime and taking a token of that crime to remember it by. it is that compulsion that, is really horrible, that makes them remember it and want to remember it over and over again. We do see it happen. And, it's not very smart because, yes, it is going to end up being very strong evidence in the case against them.
Referring to some of the other cases we've covered too, because there almost seems to be a pattern throughout the cases. And in some of them, we've seen a teacher be arrested for a specific act with a student. And as the investigation goes on, more students come forward. We learn about past issues that they may have had with prior students. Is that something we could see here, that investigators are going to kind of dig into the kids that she had access to as a teacher, see if anyone else was experiencing the same thing?
They absolutely should. Investigators should be following all leads. So when they interview this individual who was taken advantage of, this student in particular, they're going to possibly ask, do you know of anybody else that has experienced this with this woman? And where they might fail in that particular interview, I think the school, they've already sent out, a letter to parents. If I'm a parent in the school, I'm asking my child, did anything happen to you? Did anything happen to any of your friends? Did you know about this? Did anybody else talk about this woman? Supposedly she's in her early 50s. So I imagine she's been teaching for quite a while. So she's had access to these kids for quite a while. If I'm the investigators, I'm wondering, how is it possible that this is her first victim? So I'm definitely looking into that if I'm on this case.
As you said, she's in her 50s, so she's been teaching for decades, it's possible, and going across hundreds of students. Would it make things more difficult if a student who graduated, let's say 10 or 20 years ago, is now coming forward because cell phone data isn't quite the same? Obviously, there wouldn't be any sort of DNA or data in that way. Does that make things more complicated if that's the case?
Interesting. So, right, there's also the statute of limitations that could get in the way. Anytime there is a delayed outcry, is what we call it, a delayed disclosure of a crime, it always ends up being a more difficult crime to prosecute than if there's an immediate one. However, there are tons of studies that explain why people don't come forward immediately, why they hide what happened, whether they feel shame, embarrassed, they feel like there might be retaliation. There's a zillion reasons, good reasons, why people don't come forward immediately. But that's not to say that we shouldn't encourage people to do so, because there are ways to get justice. Even if, for example, somebody comes forward 20 years later and the statute of limitations has passed on their case, they can still potentially be a witness in the current prosecution, because there are ways to get that testimony in front of a jury because of that teacher's what's called prior bad acts. And there are certain legal things, legal check marks that you have to meet in order to get that testimony in front of a jury. But a lot of times it is allowed to show motive, to show lack of accident, to show identity of the person. So it could make things complicated for their particular case. But certainly I would encourage people to come forward if something happened to them, because it could strengthen the current case.
Speaking about her profession specifically, the fact that she was a teacher and had access to all these students, it's just really hard to imagine. But as you said, the school has placed her on administrative leave for now. She's only been charged, so she hasn't been convicted of these crimes. But let's say that she's found guilty. What would happen then? Would she have to register as a sex offender?
Yes. So depending on what she's convicted of, but assuming she's convicted of these kinds of sex crimes, then yes, she would have to register as a sex offender. She would lose her license, her teaching license. She would have to report publicly where she was living so that people could know that their neighbor potentially is a sex offender. And there is a process whereby she is deemed either a level 1, 2, or 3 sex offender, depending on her dangerousness and her potential for reoffending. So yes, most likely, depending on what she gets convicted of, she would have to register.
Okay, so about this specific instance, I know that there's a lot of questions still ahead, but what we do know is that Allegedly, this happened at a construction site, like a home was under construction, and that's where this sexual contact happened. Is that location important? I mean, one can infer that these people are going to be building this home during the day. It's after hours. They're probably not going to be there. No one's going to be coming and going from this home. Is that almost like a consciousness of guilt, the fact that she's trying to go somewhere where no one would be?
Sure. I mean, I don't know what kind of defense she could ever have for this, right? But the truth is, yeah, this is just yet another thing that she is doing to try to hide what she's doing. And if you're doing something that you're trying to hide, then presumably you know it's wrong. Is the point, right? That's your point. That's my point. If she were, doing something in public or not trying to hide what she was doing, I mean, I don't know how she could ever say that she didn't know that it was wrong, but at least she could have some sort of narrative there where she was like, I had no idea. But this kind of situation is what we like to call statutory. It's a crime statutorily. So ignorance won't even matter anyway. If she did have sexual contact with this individual, then it is a crime, whether or not she knew that person's age or whether or not she knew it was a crime.
You mentioned her defense and that we're not sure which route she could even take, but let's say she does plead not guilty to this case. What could that look like? I mean, obviously more details would have to come out, but let's say this student actually was 18 years old. Would that benefit her defense in any way?
Of course, it would benefit simply because, even just with respect to mitigation or sympathy that she might get from a judge or jury, it's not, I guess, as offensive to a judge or a jury to hear evidence and see evidence of a sexual act with an 18-year-old versus a 13-year-old. I mean, that just in and of itself could give her some points, I guess. But again, there is that charge where as long as she was that person's teacher or was in a teaching capacity and he was a student, there is still a crime. So it mitigates certain things and it might, help on a certain level, but it would not eradicate the charge.
In a lot of these cases, we do see them ending in a plea deal because obviously if this is going to trial, a lot of details about this defendant's life are going to come out. And sometimes they feel that a plea deal is the way to go. What do you think in this case, that it would end in a plea deal or she would want to go to a jury trial?
A lot of juries are very eager to convict in a case like this. So, if I were her, I would probably try to strike a deal. However, on the other hand, we do see a lot of people who are facing these kinds of charges want to go to trial because it's a hard pill to swallow for them to take a plea deal in this case where they're going to be probably a convicted felon and have to register as a sex offender. I mean, that is a scarlet letter that you really could never rid yourself of. So I think a lot of it will depend on how cooperative the student is, whether he's willing to testify against her, how strong the evidence is. Like you mentioned earlier, are there text messages? Is there proof that's kind of uncontroverted with respect to the case? So I think that she'll probably work with her attorney and see just how strong the case is. If it's not as strong, maybe she'll get herself a better plea deal, or maybe she'll choose to go to trial here.
Right now, she's being held on $50,000 bond. What do you feel about that number? Do you think it's appropriate?
We've seen various levels of bail in these kinds of cases. A lot of the time, it depends on the person's record. Do they have a previous history? And also how bad the crime is, what level felony it is, how many charges there are, how many victims there are. I mean, technically, bail is only supposed to be set as a deterrent from fleeing. It's supposed to force people to come back to court to face their charges. It's not necessarily supposed to indicate, whether the case is the worst case in the world versus not the worst case in the world. But we all know that it does happen anyway, that bail is set at a higher limit when the case is worse than others. I think 50,000 is a little low compared to other cases that I've seen and heard about where charges are sexual in nature of a minor. So, and especially, in Texas, I would have expected maybe a higher level of bail, but I guess maybe that kind of will explain itself later when we find out the details of the case.
Jennifer Massey's case is still under investigation, and if you have any information, contact the Comal County Sheriff's Office in Texas. Reporting for Law&Crime, I'm Gillespie.